Dual agency. I want you to note up front that dual agency many times will be called something referred to as limited agency. So what is dual agency? We just explored single agency relationships where there's a customer and there's a client on either side of the fence. In dual agency, this is interesting in the fact that in a dual agency relationship, there's one agent, or one person, if you will, is representing both sides of the transaction, and both sides are being treated as a client. So in dual agency practice, both sides become clients. And as you may be thinking, that would mean that both sides we're working for both sides, we're representing both sides. And in essence, that's true 100% of the time. We are representing both sides in a dual agency relationship, and both sides are treated as clients. Both sides, in essence, are hiring us to represent them and their best interests. Both sides become clients or principals. Now, what does that mean? We owe both sides fiduciary obligations. And as you learned earlier, cold AC, care, obedience, loyalty, disclosure, accounting, and confidentiality, in theory, we would owe to both sides. But again, that can be quite challenging. There's some of these fiduciary obligations that are a little bit strange to be able to offer to both sides, to do it fairly and equitably in a lot of opinions and a lot of mindsets out there. And what I want you to know is for limited agency, and this is the reason why they call it limited agency, we don't owe both sides the full care, obedience, loyalty, disclosure, accounting, and confidentiality. With limited agency, we allow the practitioner, the agent standing in the middle, to basically drop care, obedience, and loyalty. So for the first three letters, drop them. We owe both sides disclosure, accounting, and confidentiality. I do want you to take note of that. So in your notes or in your book somewhere, please write down or mark that as a limited agent, we owe both sides disclosure, accounting, and confidentiality only, which is why we call it limited agency. Now, would you say it's fair for me to say that I shouldn't or should not represent both sides and not tell either side? And that makes perfect sense. Both sides of the transaction, both clients need to understand that one agent, me, I'm sitting in the middle of the entire transaction. So what I want you to note is that we have something called undisclosed dual agency. Well, undisclosed dual agency is prohibited. So I do want you to know that we have something called dual agency disclosed versus undisclosed. And an undisclosed dual agency is not allowed anywhere in the country. We have to tell both sides that they're being represented and both sides are being treated as clients. So I want you to know on the exam, any questions referring to undisclosed dual agency, it is prohibited. Now, dual agency in this particular state in the Commonwealth of Massachusetts is allowed. We do call it limited agency. And with dual agency, again, we are representing both sides as clients. Now, there's a disclosure that has to be given to all participants in dual agency, and that's called the Massachusetts Consent to Dual Agency Agreement. Both parties need to give what we call affirmative assent, which means assent meaning permission or their understanding of the events. They're both agreeing that they are being represented by a single agent. If that's given and everybody understands what's going on, then dual agency or limited agency is allowed to be practiced. However, undisclosed dual agency is prohibited everywhere. In the next section, we're going to talk about the various hybrids, such as designated agency and a facilitator.